Good morning, everybody. Welcome. We'll give it just a minute for everybody to kind of file in and settle in for the next hour and a half with us. If you'd like to go ahead and put into the chat box where you are joining us from in lovely Monterey County. We always like to see that. Sometimes we get people not in the county we think we're presenting to. It's always fun to see. Excuse me. All right. Hello, Laura. Welcome. Nice to have you here. Pacific Grove. Excellent. Welcome. All right. We will go ahead and get started. So again, good morning, everybody, and welcome to the 2023 Labor Law Update, sponsored today by the Monterey County Workforce Development Board. My name is Tara Brennan, and I'm the events manager here at CEA. And before we start today's webinar, I'll just go over a couple of housekeeping details with you. Excuse me. Your audio is muted, but we do love to have your participation. So if you have any questions pertaining to the presentation, go ahead and put those into the Q&A box. That's just down at the bottom, kind of to the left. Our presenters will be monitoring that so that they'll be able to help you with your questions. If you have any simple technical difficulties, or for whatever reason you did not receive the handouts that were sent out with the link this morning to this, go ahead and put your email into the chat box. That's where I will be, and I'll be able to send those back out to you. There is going to be a quick 30-second survey. There will be actually a slide that comes up with a QR code. So if you take just a couple of seconds to fill that out for us, we would really appreciate it. We love your feedback. Also, just to be noted that this webinar is being recorded, and it will be available on the Monterey County Workforce Development Board's website later in this week. So now I'd like to go ahead and introduce Jerry Hernandez. He's the Management Analyst and Business Services with Monterey County Workforce Development Board. So Jerry, welcome.
Thank you very much, Tara. I'd like to welcome everyone to the webinar today. Before we begin, though, I'd like to briefly mention the kind of services that we offer, and invite you to please contact us if you do have interest in any one of these. Obviously, you have interest in the webinars, and I'll talk more about those. But first of all, we recognize that businesses today are in the process of stabilizing themselves, strengthening and looking at ways to grow their business. And we can assist you in three ways. Primarily, in category one, you'll see recruitments. We offer no-cost job and career fairs. We have customized recruitments, which means we can work with larger businesses and have job fairs specifically for the business. We have a job board on our Monterey County Workforce Development Board website, and we're getting quite a bit of assistance or use of that from the business community. And we have other promotional activities. Training is an important part now of the recruitment process, and both for incumbent workers or those workers who have been with you, your company or business for 6 months or more. We can help upskill them. We have training grants for that. We have on-the-job training, which are funds that help you to recruit, and we can pay the training costs for those who are initially coming into your workforce, those that don't have the skills, but you want to train them. And then layoff aversion, which means we would like to have the opportunity before you have to lay off an individual to work with you to see if there's any way of retaining them, or if not, we can see if we can get other companies who may be interested in hiring those people who would be laid off. We also work with EDD, and there are resources available to them. The third column, entitled Resources and Other Services, we are working right now until May to work with micro businesses. We have $2,500 micro business grants, 5 or less employees. So if you're interested in that, you can contact us. We also have the Human Resource Hotline, which will be spoken about a little more. And then for business individuals who want to start their own business, we have partners and resources for businesses that want to start, grow, finance their business. Rapid response, if you are laying off, we provide some services there in terms of looking at downsizing or supporting your downsizing process. The next slide is going to show you a little bit more about a calendar. You may have received this, but this is showing the overall year's activity. There's going to be about 4 webinars that we're offering. The next one being Leading Change, Surviving Change. And so we invite you, that's on Wednesday, March 8th, same time. So the second Wednesday of the month, next month. We were talking about the fact we're already in February. That's hard to believe, but we are here now. And so next month, March, is the next webinar. The following month in green, you'll see there, it says on-site presentations below the picture of our offices. And it's going to be here at our offices, the second floor of our office at 344 Salinas Street. That is entitled Hiring Right the First Time. That's going to be interesting because you want to hire, but you want to make sure you're getting the right candidate. There's a process for doing that, and that's going to be a very good on-site presentation, and we'd like to invite you to that. You're also going to note that our partners on that include the chambers and business associations. We hope to get a lot of support in that on-site business, and they're supporting this effort as well. The next slide is going to just give you my contact information. You'll see it at the end of this presentation. So if you want to contact me directly, 831-755-5393. You'll see this slide again. You'll be able to get my email address again. So I invite you to call. I look forward to speaking with you. Now I'll turn the stage back over to Tara. She'll take us into our webinar.
Great, Terry. Thank you so much. Yeah, and I'll go ahead and put all that information too into the chat just so it's easy to lift it. And I do see that there are some people who did not receive the handouts. I just sent them out to you. So again, if you need the handouts, they were attached to the reminder email that went out. But if you don't have those, go ahead and put your email into the chat box and I'll send those out to you as well. Okay, so with all that said and done, I would like to go ahead and introduce Natalie Jimenez. She is our Director of Member Services who will be joining us in the background. And our presenters today are Juliana Gabriel and Mary Bradford, our HR directors here at CEA. So ladies, it's all yours.
Great. Thank you so much, Jerry. And thanks, Tara. Very glad to be with you today. Hi, everybody. I'm Mary. I'm going to be the first presenter today. Juliana is going to be in the background for the first half, taking all of your Q&A questions. So feel free to do your best to stump her and throw some tough questions at her, and she'll be monitoring those in the Q&A, and then she will be back with us for the second half of today's training. But I just want to welcome everyone from the Workforce Development Board, all of the members that are joining us. It's great to have you with us. And one of the amazing benefits that they provide to you is this HR hotline that Jerry mentioned. And this is your hotline number. It's 888-217-6899. And that's the number you want to make sure you call anytime you have questions on wage and hour, on harassment prevention, policies, leave of absence, anything like that. We are happy to help you. And this is provided as a no-cost hotline to you. So when you call us, there is not a charge or a fee for that. We are just here to try to help you and make your life a little easier. And if you have a big issue that requires a little more assistance, we can help you out with that as well. So give us a call anytime you have questions. We're always really, really happy to help you. And let me give you a quick introduction into CEA, because you may not be as familiar with us. We are not part of the county, but we partner with the county. And we are the California Employers Association. We're an HR consulting company. And we're here to bring you peace of mind and try to make your life a little easier and figure out HR in California, which, as you know, is ever changing and very confusing at times. And our job is to try to help you through that. So you don't have to be the HR experts. You can give us a call and we'll walk you through those issues. So again, you've got that hotline number, and that is your specific number to call. You're going to see on all of the slides, we have our main 800 number. But go ahead and give us a call on the Monterey hotline number anytime that you have a question. But we can help you out with all those other issues that I mentioned before, as well as if you need help with a customized handbook, if you need some additional training for your employees, just let us know. We're happy to help you out. And I do encourage you to visit our website, which is employers.org. You will find lots of great articles. We've got a blog and lots of resources are out there for you. Excuse me. I do want to remind everyone that CEA is not a law firm. So when you're calling us, you're not getting legal advice. You are getting best practice, you're getting options, you're getting information on what the law, the regulations, and the guidelines are. But if you ever do need to consult with an attorney, we always advise that you've got kind of an attorney's number in the old Rolodex, just in case you need to get a hold of somebody. So we always recommend you do consult with legal counsel on any matters of legal significance. Here is what we're going to be covering today. Juliana and I are going to tell you about a lot of things that have been going on in California. I'm going to start off by talking about some changes with pay transparency, some new laws when it comes to leave and who is able to take leave in California. Talk a little bit about wage and hour updates, some changes with minimum wage, and our new exempt salary guidelines. And then Juliana is going to talk a little bit about infectious diseases in the workplaces, some workforce forms that you need to know about, and then some industry-specific laws. So let me jump into our first section, which is pay transparency, bereavement leave, paid sick leave, and this new idea of a designated person when people can take some time off, as well as a new category that we have in California as a protected class, which is called reproductive rights. So I'm going to break each of these down for you here. All right, so pay transparency. As you know, in California, a lot of different laws apply based on employer size. So sometimes a law will apply to every single employer in California, or it might apply if you have 15 or more, or 15 or more employees. Anytime Juliana and I are talking about employees size or employee headcount, we're talking about all employees in your organization. So if you have 10 employees in California, but you have 20 employees in Nevada, you would be considered a 30 headcount employer for purposes of any of these laws we're going to talk about. So just keep that in mind. California just wants you to count all of your employees. So when it comes to the first rule for all employers that you have to follow, you now need to make sure that you are providing pay scale, and that's going to be that salary range or an hourly range to any current employee who asks what the salary range is for their current position. So if somebody comes up to you and they say, can you please tell me I'm an IT tech? Can you tell me what the salary range is for an IT tech? So you want to be prepared to respond, salary range for an IT tech is between $25 and $35 an hour, or whatever it is for your business. But this is an opportunity for you to start really looking at the salary ranges that you feel individuals fit into. And this is also an opportunity for you to think, you know what, everybody is called an IT tech. But maybe we really need IT tech level 1. Maybe we need IT tech level 2. So you might start to see some leveling because maybe you need to have a lower level IT tech make between 25 and 35, but really an IT tech level 2 should be between maybe $35 and $55. So you want to start taking a look at salary ranges, taking a look at where your employees fit into those. Now, when it comes to pay scale information about a salary range, that does not need to include bonuses or tips or anything along those lines. It's really just looking at base pay for a particular position. The other thing all employers need to do now is maintain wage rate history for all of their employees. So as of January 1st, 2023, you want to make sure that you're tracking that information for each of your employees. So you're going to track the job title, you're going to track the wage that they are paid, and as that changes, you're going to make sure that you keep records of that so you now have a history of that. Now, after an employee terminates, you also want to hold on to those records for at least 3 years following their separation. Now, in general, you really do want to keep the majority of your personal records for a minimum of 3. We kind of even like 4 years a little more, but there's a lot of different record retention requirements based on different laws and regulations. So make sure you take a look at that so that you're being consistent with that, because you want to make sure you're holding on to those records as long as you need to in case an issue ever comes up that you need to address. Now, if you are a larger employer, if you have 15 or more employees, there's a big change when it comes to posting jobs. So if you go to post a job on Craigslist or Job Jupiter, on LinkedIn, anything like that, you're now required to include that pay scale information in a job posting. So even if you use a third-party recruiter, for example, and they're posting a job for you, maybe they're doing that initial resume screen and then they're sending you the candidates, you need to make sure that they are posting that pay scale information in that job as well. Now, this is one of those reasons you really kind of want to double check anyone that you're working with, especially if they're outside of California. They're not always familiar with our laws. I was actually just speaking with a group in Pennsylvania yesterday, and they couldn't believe some of the things that they weren't aware that they needed to do for their California employees. So Sometimes those out-of-state businesses just aren't familiar with our laws because California really is unique in that perspective. So we need to make sure that if we're working with a third party, they're including that pay scale information as well. Now, again, that pay scale information just needs to be that base of that particular position. It doesn't need to include other potential earnings of bonuses, commission, anything like that. So again, just as you're providing that base pay scale information to your employees, that's what you now need to include in job postings as of January 1st, 2023. A couple of next steps for you to consider, depending on what applies to you in this particular scenario. But this is where you want to work on creating that job title wage rate history for all of your employees. Go ahead and look back as of January 1st. If you have an HRIS system that can do it for you, fantastic. If you just need to create an Excel spreadsheet, go ahead and do that. But you just do want to make sure that you're recording all of that wage rate history. And of course, we're going to make sure we hold on to those records for 3 years after that employment ends with that particular employee. And if you have 15 or more employees, start working on updating any job postings. So if you have a job posted right now, you want to make sure it includes that pay scale information. Now, you also might be thinking, I have no idea what the pay scale should be, or I'm not sure where I should start. We do have a great partner we work with that does compensation surveys. If you're looking for a particular position or a particular industry, they can help you with that. I know many of you might already be part of a particular association based on the industry you're in. Sometimes they have salary surveys that they can provide some good information. So start taking a look at those resources so you can get set up so you don't really have to start from scratch, make it a little easier for you. And just a reminder, and this has been around for a couple of years, the law already required employers to provide pay scale information to their applicants. So if somebody was coming in to interview and they got through that initial interview, and they could then ask you, can you give me some pay scale information on this position? So it's kind of been coming along for quite a while. And I can tell you, even though California is kind of leading the way in pay transparency, lots of other states are starting to do this too. Colorado's been doing it for a while. If you've ever looked at job postings, oftentimes it'll say, for this position in Colorado, the range is X to X for this particular position. So other states are kind of getting on board with this. And I think we'll see this much more frequently for job postings all over the US pretty soon. All right, so we have our first poll for you today. We're just kind of curious what you have been doing. Can you tell us here, did your company include pay scale information in job postings prior to this new law? So I just launched a poll, and if you wouldn't mind just clicking one of those answers, we'd love to see what you've been doing. So you can do yes, we've already been doing this, we're pros. No, we've never done it, or only for select positions. It looks like a lot of you have already been doing this. That's fantastic. I will share those results here in just a second. Got a lot of answers coming in here. Fantastic. All right, let me go ahead and end that poll, and I will share those results with you. So it looks like over half of you have already been doing this, so you're probably familiar with it. And it's possible if you're an out-of-state employer, maybe you have offices in Colorado, you just decided to do this anyway. But it is fairly common. For those of you that have never done it before, I would encourage you, if before you thought, I don't want to tell people how much this position pays, I think it can really be a positive because it can help kind of weed out some of those applicants that maybe it's just not the right salary position for them. So for example, if you are looking for a position and you can only pay between $30 and $40 an hour, and there's an applicant out there that simply can't take less than $50 an hour, then it just kind of lets them know, you know what, that's just not the right position for you. Good luck somewhere else. But it can save you kind of a lot of time in that screening process, because you can weed out some people that you just know it's just not the right compensation level for them. So I would try to see it as a positive. It's also a good way to let people know, hey, this is what we're paying, being upfront and honest about it. And I think most businesses find that it works out really well for them. And for those of you that have been doing it for some positions, I know sometimes it's common if you just did it for a entry-level minimum wage position, just to let people know we're really only paying minimum wage. Sometimes people only did it for higher level positions. So now I think you'll see there's going to be a little more consistency. And I think, you know, if you have any hesitations on that, feel free to call the hotline. We'll tell you it'll be a good thing. You don't have to be worried. We'll get you set up. All right, so here's another new change. Bereavement leave. We now have unpaid bereavement leave in California. This is something they've been talking about for years, and it finally went through. So if you have 5 or more employees, you now need to provide your eligible employees with 5 days of unpaid bereavement leave upon the death of a covered family member. And I'll show you who that is here in just a second. In order to be eligible, they have to have worked for you for at least 30 days before that leave. That leave needs to be taken within 3 months of the date of the death. And that leave does not have to be taken consecutively. Oftentimes what can happen is if somebody passes away, maybe they need to get together with the family the next day to deal with immediate issues, but then perhaps the service won't be for another month or two. So that's why it can be taken intermittently. It can be broken up. Now, you as an employer can request appropriate documentation. So if you want to ask for an obituary or a death certificate, you can do that. But this is where one of the first reminders I will give you to be consistent. Make sure if you ask it of one employee, you're asking it of all employees, so you can be consistent in your policies. So this also means you need to update your policy. You need to update if you had a paid bereavement leave policy already. I'll talk about that in just a second. You need to make sure this now matches up with that, or you're consistent with that and you're clear in what your own policy is if you do offer some paid time. And also any forms that you might have for paid time off, make sure that you, or unpaid time off, that you include bereavement as well. Now, again, this leave is unpaid, but some of you might already offer a paid bereavement leave. Oftentimes employers do. Maybe they'll say they'll pay 2 days of paid bereavement leave. So you just want to make sure you clarify really what your paid policy is versus what your unpaid policy is. Now, the other thing to keep in mind is bereavement leave is per death. So if someone loses a covered family member in February, and then they need to take time again in September, they would have another 5 unpaid days of bereavement leave. So you want to make sure you clarify for your own policy. If you only want to pay 2 days of bereavement leave per year, make sure you're just clear in your policy what time is paid versus what time is unpaid. And of course, we always want to make sure we maintain confidentiality. Anytime an employee is out of the office really for anything, if it's for bereavement, if it's for a medical condition, any reason, we want to be very confidential with that. And we just can say the employee's taking time off, we expect them back on Tuesday. That's all I can say at this time. If the employee gives you the permission to share, that's perfectly fine, but we just don't want to make sure we're disclosing any personal information without their approval. Now, when it comes to covered family members, that is spouse, registered domestic partner, child, parent, parent-in-law, sibling, grandparent, and grandchild. So keep in mind that those are the individuals that are covered. Now, also, if you do paid bereavement leave, if you want to have different covered family members for purposes of paid bereavement leave, you can do that. But when it comes to the state benefit of unpaid bereavement leave, you need to make sure you're being consistent, and it's the covered family members that are required by law. So let's transition over to another big law that many of you have had to deal with, and that is CFRA, or CFRA, depending on how you like to say it. But that stands for the California Family Rights Act. And for those of you that are larger employers, you're very familiar with this because you've been dealing with it. If you had 50 or more employees, a couple of years ago, they lowered the employee threshold. So now it applies to businesses that have 5 or more employees. And this provides your employees with 12 weeks of unpaid guaranteed job reinstatement every 12 months. They're able to take up to 12 weeks, again, unpaid. When they are on this leave, though, their benefits need to continue, and they need to continue at the same level they were at prior to the leave. So, for example, if they paid $250 per month towards medical benefits, and you paid $250 per month towards medical benefits, you both continue to pay that amount. So you pay your portion, and the employee is responsible for paying their portion. Now, in order to be eligible, they need to have worked for you for 12 months. And in the prior 12 months, they need to have worked 1,250 hours. So that's a little more than part-time, how that works out to. And of course, keep in mind that CFRA runs separately from PDL, which is pregnancy disability leave. Those are 2 distinct leaves. So if you are a covered employer, you need to keep in mind you need to have a CFRA policy. You need to make sure you've got a poster that is posted in your workplace. And of course, you're using the mandatory forms. As a reminder, always make sure that you are using California forms when it comes to CFRA and FMLA, because the feds have some forms that ask for information that you cannot ask in California. So make sure you're using California compliant forms. Now, I've already mentioned a couple of times having policies on these things. Excuse me. And some of you might be thinking, I don't have a policy, or my handbook is 10 years old. If you need a DIY handbook template, CEA has one that's been written and put together by the HR team and attorney approved. It is very user-friendly. It is really written in a very conversational tone, so it is not horrible to read. I'm sure many of you have read horrible handbooks in your past. So if you need some assistance with that, that can be found on the CEA store, and I can drop a link into that later, Juliana, if you get a chance, if anyone needs that. And all of these new policies that Juliana and I are talking about, those are all included in our 2023 handbook, so everything is already written and ready to go for you. All right, so let's talk about the covered reasons for CFRA. Most commonly, it's used for baby bonding, and that's again taken after pregnancy disability leave. It can be for the employee's own medical condition. Maybe they need to have a knee replacement. Maybe they hurt their back, something along those lines, so they can take time off for that. If they have a family in the armed forces, then take time off to be with them. And also, again, caring for a family member with a serious health condition. Excuse me. So we also have this new category called a designated person. And this applies to PSL as well as CFRA. So an employee can now take time and use their paid sick leave or CFRA if they need to care for this designated person. The employee can designate this person at the time of the leave request, but you as an employer can limit them to one designated person per pay period. So, or excuse me, not per pay period, excuse me, per year. So this is another opportunity for you to update your policy and forms when it comes to CFRA and PSL to make sure that you put an employee, for all the other covered reasons that we talked about, they can also take time off to care for a designated person. Let me show you what those definitions look like now. So for CFRA, they say a designated person is defined as any individual related by blood or whose association with the employee is equivalent to a family relationship. PSL is much more broad, and it says a person identified by the employee at the time the employee requests paid sick days. So those are the two different definitions for designated person, but you want to make sure if your employee says, I need to take 2 days of paid sick leave to care for my roommate, they're my designated person. You want to make sure you now allow them to take that time. And here is our new protected category in California, reproductive rights. So if you've heard of FEHA before, that is the Fair Employment and Housing Act. And this new change, the Senate Bill 523, expands FEHA to prohibit discrimination against an applicant or an employee based on any sort of reproductive health decision-making choices. So that means that you as an employer can never require an applicant or employee to disclose any of that information. And that can be a decision to use or access a drug, device, product, medical service for reproductive health, anything along those lines. So as always, this is my reminder to you that you want to make sure when you are interviewing an applicant, when you are dealing with a current employee, the only thing you should be focused on are objective job-related factors. So we look at what are the requirements of the position? Does that individual meet those requirements? We don't want to look at anything that has to do with the color of the skin, if they're married or divorced, what their reproductive right choices are, or reproductive health choices are, anything along those lines. We want to stick to objective fact-based factors, and that's how we make decisions, and that's how you can stay out of trouble and not make a discriminatory choice as an employer. So again, this is another policy update that you will need, because in your handbook, in your harassment prevention policy, you have to list all of the protected categories in California, and reproductive rights is now one of them. All right, so let's take a look at our takeaways here for our first big section. I know that's a lot of information I just gave you. So make sure you create those job titles and your wage rate history records. You've got a bunch of policy updates you need to do, your bereavement, your CFRA, your paid sick leave, that's EEO, that's Equal Employment Opportunity, and FEHA, Fair Employment Housing Act. And then, of course, mandatory 2023 poster updates. We always suggest you get a new poster for 2023 or each year. And you can also grab one of those on our site. We have them in English, we have them in Spanish, we have paper, we have laminated, whatever you need for your particular business. But you do want to make sure that you always post a poster in your common employee area, if that's your break room, if that is the yard where the crew comes to pick up equipment before they head out, whatever it is. You want to make sure you've got one of those posted and it's up to date, because there's fairly expensive fines if you don't have a current poster that has all of the required postings in it. And at the bottom of the slide, you'll notice there's a bit.ly. That's just, if you're not familiar with bit.ly, it's just a short shortcut to take you to a particular website. And again, you can find all of these just at employers.org. Right, let's transition over to wage and hour updates. Let's talk about something different. All right, so minimum wage in California went up to $15.50 as of January 1st. Due to inflation, there was a little bigger bump. It was supposed to be 15, but they raised it up a little more. So now every business in California needs to be paying their employees at least $15.50 an hour. Now, the reason why minimum wage is important is you always want to make sure you're paying that, but it also affects the exempt or the salary wage that you need to pay anyone that you classify as an exempt employee. So that now takes it up to $64,480. That is a very large bump for small employers, especially. It went up about $6,000. So that's quite a big change. So some of you may need to change your exempt employees back to a non-exempt employee. You are perfectly allowed to do that in California. Remember, everyone automatically defaults to a non-exempt hourly employee unless you, the employer, can show that they should be something else. So lots of employers have been changing their employees back to non-exempt due to this big salary jump. We do have a really nice little cheat sheet with a couple of tips on how you can do this, because as a non-exempt hourly employee, remember, we've got to have our employees clocking in and out to start and end their day, clocking in and out for their lunch, and they're going to be paid overtime and all those kind of good things. So make sure you're following along with those new rules. Now, the other thing to keep an eye out for is that there are more than 35 cities or counties that have their own minimum wage requirements. So we have a bit.ly here for you so you can take a look and find out if any of your employees might be in one of these cities. Remember, it's where the employee is physically working. So for those of you that might have remote employees, this is why it's really important that we know where our employees actually are, because we need to make sure that we are paying the appropriate minimum wage for the area that they work. Also, we do have some cities that have their own paid sick leave requirements. LA has it, San Diego has it, several other cities scattered around the Bay Area. So make sure you know where your employees are working, so you can make sure they're getting any of those benefits that they're entitled to. Again, there's a bit.ly right there on the bottom of the slide for you, so you can take a look. It's a really nice, handy user guide, and it's quite amazing how many cities have different wages these days. It's changed quite a bit, so make sure you check that out. All right, we have another poll for you. We would love to hear, are you affected by minimum wages? So is your business paying different local minimum wages because you've got employees in different locations? So if you can just tell us yes, no, we don't have anybody else, or uh-oh, I'm not sure, because I didn't know about those 35 different locations, which is quite possible. All right, so it looks like, all right, we've got most of our answers in here. All right, let me show you those results. It looks like about more than half of you don't have to deal with localities, but about a third of you do. So even if you're not paying your employees minimum wage, it's always a good idea just to check that chart to see if there's anything else, specifically paid sick leave, that you need to keep an eye out for. And for those of you that didn't know, please don't panic. This is an opportunity to correct if you've made a mistake and find out just to make sure that you are paying the correct minimum wage. Now let's go to our next slide, which this is why our parents always told us that we should be doctors or computer software professionals, because they have even higher salary requirements. So in the state of California, a physician or surgeon must be making at least $97.99 an hour in order to be exempt, and a computer software professional needs to be making $53.80 per hour. So if you have, we don't see this too much with physicians, but I do see this a lot with computer software professionals. Do make sure that you are not misclassifying your IT tech people. So when it comes to having an exempt computer-based professional, it's normally a very, very high level position. So this is maybe your IT webmaster or your director, a really high level position. A lot of your IT techs, those are all going to be hourly positions, and I see people misclassified all the time. So take a look, because remember that salary level I was talking about, the $64,480, that is just one component of classifying someone as an exempt employee. So we always look at the salary, but then we also have to look at their duties, and there's a duties test that they have to meet in order to be exempt. So make sure you're taking a look at both of those to make sure somebody really qualifies as an exempt employee. And remember, you're always safer keeping someone as a non-exempt hourly employee in California. So let's talk about mileage reimbursement in California. Every year, the IRS sets a mileage reimbursement rate. And they say, if you pay your employees this rate, that is paying for gas, that's paying for insurance, it's paying for wear and tear on a vehicle. And for this year, as of January 1st, they set that rate at 65.5 cents per mile. So it went up 3 cents from a mid-year update they did last year, just because gas was so out of control. As we all know, it still is here in California. So they say if you, an employer, are paying 65.5 cents a mile, you are paying the cost for an employee to use their personal vehicle for driving on behalf of the company. Now, in the state of California, there's something called Labor Code Section 2802. Basically says anytime an employee incurs a cost on behalf of the business needs to pay that employee back. So a business needs to pay an employee back for using their personal vehicle and driving around, doing company errands. Maybe they are running to the bank to make deposits. Maybe they're driving out to client sites and they're required to use their own vehicle, whatever it is. But what we always advise is that you pay that IRS rate, because when you pay that IRS rate, you are saying, I'm paying for your gas, I'm paying for your insurance, everything is covered. If you pay less than that, which you can, because you're really just supposed to pay a reasonable amount, but if you're not paying enough, an employee could make an argument and say, I got a flat tire, I want you to pay for a new tire, or there was some damage to my vehicle, I want you to pay me that because you're paying less than that IRS rate. So we always advise pay the IRS rate, because that's what the feds are saying. This covers wear and tear and any other associated cost when an employee is using their vehicle for business. Now, another big change for you to keep in mind, and this one has been evolving over the past couple of years, is time rounding. So about 10 years ago, there was this big case, See's Candy, we all know and love it. And See's Candy had this that went to a California Court of Appeal, and they said, yes, it's okay for employers to round when an employee starts or end their day. They can round to the nearest quarter hour, as long as it's neutral and it doesn't adversely affect the employee. So employers have been using rounding for quite a long time. So say, for example, an employee is supposed to start at 8:05, or excuse me, at 8 o'clock, but they clock in at 8:05, it would round back to 8 o'clock. And then later on that night, they clock out at 5:10, and it rounds forward to 5:15. So it would round to that nearest quarter hour. Now, on the face, it sounded like it was okay, but you as an employer were supposed to audit all of those time records to make sure that it wasn't being a negative towards the employee, and it worked out over time. It averaged out over time. There were lots of litigation issues with this. So now we have this new ruling that came about with Home Depot, and Home Depot has said, wait a minute. Well, not Home Depot said, Home Depot was allowing their employees to round even though their system could clock to the exact minute that an individual was clocking in. And the California Court of Appeal said, wait, that's not okay. If your system can track actual time, you need to track actual time. So now the California Court of Appeal has asked the California Supreme Court to take a look at this. So what we are advising is probably best not to do any rounding at all, because we think it's probably going to be going away once we get a Supreme Court decision, especially if your timekeeping system can round, or not, excuse me, not round, can capture the actual time an employee clocks in. Let's just use that time. We always want to make sure we're paying our employees for every moment that they're working for us. Also, keep in mind, you cannot round meal periods. That was changed a couple of years ago. So just in general, we recommend not rounding, just capture that actual time. It is much safer for you as a business. All right, here's our next question for you to just think about in your head. Is premium pay for non-compliant meal or rest breaks considered wages? So if you have an employee who doesn't take their meal period when they're supposed to, you owe them an extra hour of pay. So if you say to them, you know what, it's too busy for you today to take a lunch, I want you to work through your lunch, I'm going to pay you that extra hour of penalty pay. So the question is that considered wages? It was kind of up in the air for a while, but I can assure you now, yes, it is very clear that premium pay is considered wages. So that means you've got to take a couple of things into account. That means since it's a wage, it needs to show up on a wage statement. So you need to make sure you're putting it on your employees' pay stubs. And it has to be paid out in a timely manner because we don't want to withhold the wages from our employees. So make sure you're staying up to date anytime an employee has a premium pay or a penalty pay that's due to them. We have a really nice fact sheet on calculating the regular rate of pay. So you can make sure you're paying your employees at that proper regular rate of pay for any premium pay that's owed to them. So take a look at that bit.ly. There's a link right there for you on the bottom of the slide. And here is what an accurate wage statement should look like. Now, on this example, we put the words premium pay in red and underlined it. You do not have to do that on your statement. And it's actually not even completely clear if it needs to be a separate line item. We would recommend that you do have it as a separate line item, just so it's very clear that, yes, I owed them for 2 missed meal periods, and this is the associated rate that I paid them out. I have done my responsibility as an employer. Sometimes employers just like to add it into the wages. I just think it looks a little cleaner if you just do as a line item, so it's very clear that that employee was paid that time, because of course it's going to be your responsibility as an employer to prove that they received all the wages they were due if it's ever called into question. And also, these are all the other things that need to be on a statement. You need to make sure you've got your net wages, your gross wages. Make sure you've got the name and address of the legal entity. Make sure that matches the pay stub and actual paycheck. Those two things should match. And then just also include paid sick leave. The accrued and unused time off that's available to employees should be on your pay stub. And also, just as a reminder, if you're a larger employer, if you have 26 or more employees, you used to need to put supplemental paid sick leave on your pay stubs, but supplemental paid sick leave expired as of December 31st, 2022. So make sure you remove that from your pay stubs now, because that is no longer an active benefit. All right, got a couple more takeaways for you here for our second section. Go ahead, check those county and city minimum wage laws and paid sick leave requirements. Make sure you're following along, again, where your employees are working. Make sure you're paying that regular rate for any penalty pay that's required of your employees. Always reimburse your employees that IRS rate when driving on company business. That's always what we recommend as a best practice. And audit your employee pay stubs for compliance. Make sure that you're following along with everything that we had in our sample, especially if you use an out-of-state payroll service. They sometimes get a little confused on what needs to be on a California pay stub. So make sure you're taking a look at those every now and then, just so that you're being compliant. All right, well, we have reached our midpoint, so I'm going to stop sharing so Juliana can take it over. Were there any questions that we should chat about with the group, or we all?
Thank you, Mary. Yeah, we can talk about, so for pay scales, there's kind of always a question of, can we just do the hiring range as opposed to the entire scale for the position? So if you want to answer that while I'm taking over here, that would be great.
Sure. Yeah, when it comes to the pay range, it really should be the range for that position. I know some people might be tempted to put, it's just $25 to $28 to start, but that's not really that pay scale. So you really want to look at the low point and the high point of a particular scale for a position. Now, it doesn't mean if you go to hire someone, you have to pay them at the high point. But again, that's that opportunity, especially when you hire someone, where you talk about an improvement plan or a growth plan, so that they know there is some potential upward mobility for them.
Yeah, exactly. And I've also heard some people saying it's okay to go ahead and put the hiring range in addition to the entire pay scale, but it's just important that you have the whole thing. You can't just be the hiring range. So that's all I have for you, Mary. Thank you for doing the heavy lifting on leaves and wage and hour. She's going to be monitoring that Q&A box, so you can continue sending us your questions that you have. I'm going to dive in a little bit more into employment forms and some reminders there, starting with the I-9 form. So remember, the I-9 form is what we have to complete every time we bring on a new employee to determine that they are authorized to work in the United States and to verify their identity. The current I-9 form, you might notice if you're going to hire a new person, that it has an expiration date of October 31, 2022. And you might say, well, I've gone to the DHS website. Am I using the correct form? And the answer is yes. So even though it has that expiration date that's already passed, The DHS has just yet to publish an updated revised form. This kind of tends to happen where they lag a little bit, but you're fine if you use that form. Employers are instructed to just continue using it until further notice. And then they'll publish the updated version of the Form I-9 once that becomes available. And usually there's a grace period where you can continue even using the old form and you'll be considered in compliance for a while. So follow our blog because we make sure to publish those kinds of update and track these things so that you don't have to keep it top of mind. So that's at our website at employers.org. I also want to go over some reminders when it comes to the I-9 forms and some COVID flexibilities that have been granted and also extended. So just as a refresher, due to COVID, there have been flexibilities for employers to review those documents that are authorizing the employee to work in the United States or confirming identity remotely due to COVID-related reasons. And so we'll talk about exactly what the parameters of that is, but they have extended those flexibilities until July 31 of this year. So we're going to see that continue for a little while, where employers have this additional option to maybe do a Zoom or a FaceTime where you're reviewing things like driver's license, social security card, passport, the employers holding those the employees holding those documents up. So just to go over a little bit of history on this, back in March 2020, employers and workplaces that were operating 100% remotely due to COVID, meaning that they did not have a single person at the work site, they were allowed to do this remote review for new hires, because traditionally it's had to be an in-person review where you're sitting with the employee or some authorized representative for your company is sitting with the employee and going over those documents. Then in April 2021, they eased up a little bit more, and they said if you do not have people reporting on a regular, consistent, predictable basis, then for those people, if they are remote due to COVID precautions, you're bringing them on in a remote capacity, then you can go ahead and do that remote review of documents. So again, it does have to be related to COVID. A lot of employers assume that if they just have a remote business operations due to just ease, that they're allowed to do this. And technically, it does need to be tied to a COVID precaution. And additionally, it is a temporary flexibility. So when those employees start reporting to work on a regular, consistent basis, or when this flexibility expires, perhaps July 31st, then employers would have to do an in-person review of the documents and update the I-9 form. So it might just make sense if you can just take care of that in-person review to go ahead and do that, so you don't have to keep that to-do list on updating the I-9 form. There is some talk about the DHS updating the I-9 form when they do make the updates to it to allow for a more permanent remote review. It's been mentioned maybe for employers who participate in E-Verify. We have to see what they end up doing on that. We have no confirmation on whether they are going to allow this option more permanently. Right now, it's temporary. It's been extended a number of times, and we're looking at July 31st is when it is set to expire. All right, now I want to go over pay data reporting. So this comes from that same SB 1162 bill that Mary started with pay transparency and required disclosures. And as she mentioned, there's components based on employer head size. So here we are looking at a component for private employers with 100 or more employees. And that's talking about located anywhere. You will be covered as long as you have at least one employee working in California. So if you have 100 or more, then you are required to submit this pay data report to the Civil Rights Department. And if you're saying, who's the Civil Rights Department? They changed their name. They used to be known as the Department of Fair Employment and Housing, the DFEH. So it's the same agency. So we're going to continue with our pay data reporting to that agency. So SB 1162 this year just revised and expanded certain requirements related to pay data reporting. We've already had this requirement for a couple of years if you have 100 or more employees. So let's go over a refresher of what that is. So the pay data report is based on a snapshot of the previous year. So for 2023 reporting, we are looking at the 2022 year, and you can choose any single pay period that you would like in the last quarter between October 1st and December 31st. And you are looking at a snapshot of what employees by race, ethnicity, and sex are earning for defined job categories. So those job categories, those pay bands are provided by the Civil Rights Department. And you can imagine it ends up looking like a big Excel spreadsheet where you can see that data of how people are paid by race, ethnicity, and sex. And of course, it's to really review, are there discrepancies? Is there an argument that people are not being paid equitably and there's perhaps discriminatory practices? So it's important that you are looking at that data, constantly analyzing it, and making sure to submit this on time. The Civil Rights Department does have some user guides and the template Excel spreadsheets to fill out. So we have a link for you here. I know that they just updated these because they were outdated for the previous reporting year. Now everything is up to date and ready to go to report in 2023 for your 2022 data. So get a head start on that. It can be a bear, especially if you've never done this before. And some employers just choose to work with legal counsel on that because it can be nuanced and just a very big task to get all of that information in there. Also, you can put clarifying remarks within that report that you're submitting if you feel like it looks like there's just a discrepancy, but there's maybe a rationale for it. So that could also be a reason to work with legal counsel so that they can help you with that. So here's what's been revised in terms of pay data reporting. It used to be that it applies if you have 100 or more employees and you're also were required to file that federal equivalent of the form, the EEO-1. They've dropped that, so now it just applies if you have 100 or more employees, then you're going to be covered and you need to report to the Civil Rights Department, regardless of whether you also have to file that federal form. The deadline has been pushed out to the second Wednesday of May each year. It used to be in March, so that's some good news. It's giving employers more time to get this stuff together. So the first report for this year will be due on May 10th. And they're making you do just a little bit more math this go around. So the pay data reports must now include the median and the mean hourly rates for each combination of race, ethnicity, and sex within each job category. So mean, we're looking at an average. Median is the midpoint in a data set. I haven't taken a look at the Excel spreadsheets that the Civil Rights Department provides, but my guess is that there's probably a column or a tab that hopefully automatically calculates that for you. Otherwise, get some help from someone that is good at math. All right, and there's some new penalties. So if you fail to file this, you're looking at, for an initial violation, $100 per employee. So again, we're looking at your head count. And then for any subsequent violations after that, you're looking at it raised to $200 per employee. So get an early start on that if you're an employer with 100 or more employees. All right, so we're going to transition here into our transmissible diseases and safety in the workplace section. So our COVID section, as Mary mentioned, make sure you have your coffee for this one because this can be a little dense, but we're going to take it one step at a time and start with COVID reporting. And the good news is a lot of the rules that we've already been exposed to and operating under in the past few years are just going to continue, subject to a few changes. So we're not seeing a ton of new information. It's just a lot of a continuation of what we've already been doing. So the first here is reporting to our workers potential COVID exposure. So we've already been required to let our workers know when there's been somebody at the work site who had tested positive, and we've needed to do this within 1 business day. So where that originated under that rule was AB 685. So it was referred to as the 685 notice by employers. That bill was actually set to expire on January 1, 2023, because back when it was enacted, the legislature thought, maybe we'll be done with all of this. We won't need that reporting requirement anymore, but they have decided to extend that at least another year until January 1, 2024. So you're going to want to continue letting your workers know when there's been a potential COVID exposure in your workplace. They've eased up a little bit when it comes to outbreaks, though. So the AB 2693 removes that requirement to report outbreaks to your local public health agency at the start of this year. You no longer have to do that anymore unless there's a local ordinance that's requiring you to do that on a local level. So that's some good news. You don't have to worry about tracking and reporting those outbreaks. All right, so let's talk about how you go about doing this. So you still have 1 business day, but they've given you now a few more options in how you let your workers know that there's been a potential COVID exposure. So the first way to do it is just do what you've already been doing and distribute individual written notices to employees. And if you have any subcontracted employees, you need to let their employers know as well. And it's basically everybody that was at the same work site as that person who tested positive needs to receive that notice. You can send it via email, but of course, this requires the step of figuring out who is at the work site, who needs to get this notice. So now you have another option. As of January 1, 2023, you can just post that notice in all places where you customarily post employee notices and correspondence. So a lot of the times in your break rooms and common areas, those types of places, you might have notices to employees, the posters, the postings, as Mary mentioned. So that would be a good place to post the notice. And then you don't have to worry about exactly who needs to get this notice. It's there for everybody to view. If you provide correspondence to your employees via online portals, if you're very tech savvy, the law is clear that you also need to make sure to post it there. And you need to leave the posting up in that case for 15 calendar days. The only additional step that you need to take with this one is make sure that you keep a log of the dates that the notice was posted. So for example, from January 1 through January 15th, we had this notice up in our workplace. Just in case the labor commissioner ever wanted to access those records or you're dealing with an audit, then you'll be able to prove that. And that's also what the law requires you to do. So easing up a little bit on the administrative burden here. Now let's talk about what needs to be in that notice. This notice, you used to have to provide all of your information regarding benefits, anti-retaliation, discrimination protections, as well as your cleaning and disinfecting plans. That was a lot that you had to have in this one notice. They've eased up on that as well. They said you can provide now the contact information of someone in your organization if employees want to know about those items. So you could put the HR manager, the owner's contact information to let employees know if they want to know about their benefits or cleaning disinfecting plans, who they can reach out to. And then it's pretty standard, just everything you would kind of assume, the dates on which the employee with the confirmed COVID case was on the work site, and then the locations of the exposure. So what areas did they enter? Offices, maybe restrooms, common areas. Make sure you have that in the notice. We have a great template for you in a Word document on our COVID-19 resources page at employers.org that everybody has access to. So you can go and download this template and fill it out with the information that you need for your business, edit it accordingly, and then you can just post it up in your workplace or distribute it to your workers. Because there's that quick turnaround time of 1 business day, you want to be ready to go if this comes up. All right, now let's talk about COVID and our workers' compensation rules. Again, for the most part, we are just continuing with the status quo of what we've already been dealing with for the past couple years. So if you remember, there was a bill called SB 1159 that included some required reporting to our carrier, as well as presumptions when employees are eligible for workers' comp benefits for COVID-related issues. So those are just being extended now until January 1, 2024, another year. So this is just really a refresher, but I'll unpack each of these for you. So the first is that reporting requirement. So we've already been required to report all COVID cases in our workplace, meaning anytime somebody tests positive in your workplace, you need to let your workers' comp claims administrator know within 3 business days in writing. And this is really a tracking mechanism to figure out how many people in your workplace in a period of time have COVID. So it's regardless of whether the transmission is work-related. So even if the employee tells you, I was attending a wedding over the weekend, and that's where I believe I caught COVID, and I don't believe I caught it at work, you would still want to let your workers' comp carrier know about that for this tracking purpose. You may, if it is work-related, if it's likely that it's work-related, you may also want to start a workers' comp claim as well. So make sure you speak to your carrier about that and just clarify whether you're opening a claim, because we've heard that some carriers have assumed that when employees just report this, or employers report this, that they're opening a claim when it's not necessarily the case. They're just reporting it for the tracking purposes. Now, what happens if you have a certain number of employees who test positive? You'll meet the definition of an outbreak, and your employees are going to be presumed eligible for workers' comp benefits in that case. And so that's why we're focused on tracking how many people have COVID at one time in your workplace. So for most employers, your employees are going to be presumed eligible if you meet the following definition of an outbreak. If you have 5 to 100 employees, if 4 employees test positive at the same work site within a 14-day period of one another. And then if you're larger than that, it's based on a percentage. If 4% of people at the work site test positive within a 14-day period. What that means is that you as the employer would then have the burden of proving that the employee caught COVID outside of work in order to deny workers' comp benefits. So you can imagine that would be pretty difficult to do, maybe not impossible, but it's going to be more likely that they're going to get those workers' comp benefits. So again, this will sunset in 2024 unless the legislature decides to extend that again. For healthcare and first responders, there's rules a little bit different. It's just if they test positive within 14 days of reporting to the work site. So because those are considered higher risk, there's just going to automatically be a presumption that they're eligible for workers' comp benefits. And there is no sunset date for them. So that is going to be an indefinite rule. All right, so I saved the really fun stuff here for last. So let's talk about our definition of close contact. So stick with me here. This was updated by the California Department of Public Health in November 2022, and it seems like the definition of close contact just gets more and more complicated as we go along. But I first want to talk about why is it important to determine who is a close contact. When somebody is a close contact in your workplace, even if they're not feeling sick or experiencing any symptoms, they are supposed to wear a mask for 10 days. So even though we're not under a universal masking rule in California anymore, this is one of those exceptions where if they're a close contact, the mask does need to come back on for a period of 10 days. They're also supposed to test within days 3 to 5 after exposure, and you as the employer are supposed to offer and pay for that testing for close contact. So that's why we care about who is a close contact. Again, if they're feeling just fine, so long as they're wearing the mask, they can continue reporting to work. They don't have to be excluded. The rules have developed over time and changed on that. So that's where we're at. Now, how it's distinguished for the close contact definition is based now on the size of the workspace. So if you are 400,000 or fewer cubic feet per floor, that is going to be most workplace settings. You're going to be under this first column. Some examples are clinic waiting rooms, airplanes, most offices. And the definition of a close contact is just anyone that was sharing the same indoor airspace as that person who tested positive if it was for 15 minutes or more in a 24-hour period. So you can imagine that could end up being everybody at your work site if you're all in the same work area and they're there for at least 15 minutes with the person who ended up testing positive. When that person was infectious, they were sharing indoor airspace with them, they're going to be considered a close contact. So very, very broad. If you are greater than 400,000 cubic feet per floor, we're talking about those very large open warehouses, retail stores, certain food processing and manufacturing facilities where you can imagine it's those very large open spaces that are not separated with any walls. Then we go back to that 6-foot definition that we're all used to. It's only if someone was within 6 feet of the infected person for 15 minutes or more over a 24-hour period. So that's where we're at with our close contact definition. I would not be surprised if they update it again. That could happen. Now, I am going to also get into where we are at with the current Cal-OSHA COVID workplace standard. We expect some changes on that any day now. But I'm going to give you a little break before we get into that, a little break from COVID, and we're going to talk about this bill, SB 1044, emergency conditions. So where this bill kind of was inspired out of was employees feeling unsafe reporting to work during our wildfire seasons that we've had increasingly been dealing with in California over the past few years. And employees, whether it's due to an actual threat of fire, on the freeway or concerns about smoke inhalation, that's really what kind of drove the legislature to create this bill. And what it says is, in the event of an emergency condition, an employer is not allowed to take or threaten adverse action against an employee if that employee refuses to report to work or they end up leaving the work site because they have a reasonable belief it is unsafe to be there or to report to work. Now let's talk about what is an emergency condition and unpack that, and then we'll talk about reasonable belief. So emergency condition refers to natural disasters. So as I mentioned, wildfires would be an example. With the flooding issues recently that we dealt with a few weeks ago in California, that could be another example, as well as criminal acts. So an example there could be maybe a mass shooter situation. Those would be the scenarios where an employee would maybe have a right to refuse to report to work or to leave the work site. The law actually specifically excludes health pandemics. So an employee could not say, I don't feel safe coming to work due to current COVID transmission in the community, and so I'm not going to report to work. They could not rely on SB 1044 for that. Now, let's talk about reasonable belief that the work site is unsafe. That's going to be based on the objective person, which can vary. So if it were to end up that the employee brings a claim, it's usually left up to the jury to decide, was that person being reasonable in refusing to report to work or leaving the work site, or were they perhaps being too dramatic? So I would recommend that you err on the side of caution with that, because reasonable minds can differ on whether somebody feels unsafe and it's objective to feel unsafe, or get some legal advice on that if you're unsure and you're dealing with that issue where you have an employee that's refusing to report to work or leaving the work site. Practically speaking, what else do we need to know? You might want to take a look at your cell phone policies if you prohibit employees to use their cell phones at work or during working time, because SB 1044 is clear that in emergency situations, an employee is able to access their mobile device to seek emergency assistance or to check in on the safety of others. So just make sure that you have a carve out for that in your cell phone policy. If you go with CEA's handbook and you work with us, we've already tracked all of those kinds of things in there to make sure to have this carved out. All right, so let's go over takeaways from this section. So when it comes to safety, make sure that you are taking a look at your safety policies every so often, whether that's your injury and illness prevention program, as well as that COVID prevention program that either needs to be rolled into the IIPP or a separate program where you're focusing on COVID-related hazards. As we're going to talk about towards the end here, we're going to likely see some updates very soon from Cal OSHA on their COVID workplace standard, where we have the majority of our other COVID workplace rules. And so employers should put on their to-do list that they're going to need to update that COVID prevention program. So typically what happens when Cal OSHA makes changes, they will update their template. And so you can just then download it and fill it out, and it will have all of the new information that you need in there based on the new standard. Now, consider whether you're going to post that COVID worker notification or continue distributing individual written notices. Make sure you're continuing to report COVID cases to your workers' comp carrier. And then for CEA members, we have our COVID exposure toolkit that walks you through exactly what you need to do when an employee is exposed or they test positive, the forms that you need, it links to all of that. So make sure you're always downloading a new version every time you're going on the website, because we constantly update that. And when that new Cal OSHA COVID standard comes out, we'll be updating it again. All right, so now I'm going to get into some industry specific updates here. We have fast food, agriculture, and call centers that were impacted with some big watershed changes. And even if you are not in one of these industries, it's kind of interesting to follow, because oftentimes the California legislature will test out these bills in a certain industry, see how it goes, and then maybe expand it beyond that to other industries or even statewide. So it's kind of like reading the tea leaves of where they might be headed next. And we have some very controversial bills in this section to go over. All right, so let's start with this fast food bill, AB 257. So what this does is it created this fast food council within the DIR to set things like wages, working hours, and other conditions for fast food restaurant workers that worked at an establishment that has 100 or more locations across the nation. So you can imagine, McDonald's, Starbucks, a lot of franchisors, right, are going to be impacted by this. And the FFC was authorized to set wages at $22 an hour for 2023. So you can imagine, if somebody is working at the minimum wage of $15.50, that is just a ginormous jump potential jump to $22 an hour for 2023, and likely would have a trickle impact on other industries because a lot of people would say, hey, I want to go work in fast food because they're paying $22 an hour. So it was controversial just for that reason alone. But here's why it's even more controversial, is it's the first sectorial bargaining law in the nation where an appointed council will set these types of working standards, because typically it has to go through the legislature and the process of becoming a bill, or we're looking at a situation where it's the collective bargaining process where you have the union, if there is one, negotiating with the employer to set these kinds of standards. So it would just be a council that would just circumvent those processes and would be able to fast track a lot of these changes. You can imagine there was a lot of litigation on this that started from restaurant groups and business groups. And there was also a proposed ballot referendum to say, let's let the people of California decide on this issue and bring it to the ballot. So that ballot referendum was successful. They received enough signatures. So what has happened now is this law has been put on hold. And it's now going to be decided by the people of California on the November 2024 ballot. So we're looking at it being on hold for almost 2 years, and then we are going to see it on the ballot. So if you have strong feelings about this one, you are able to go and vote and decide how this is going to go. All right, some other big changes come with AB 2188 in the agricultural and labor relations space. This one was also controversial. There's been multiple attempts over the past few years to pass a bill like this, and it finally went through this year. And what it does is essentially establish what is called a card check process for agricultural employees that are seeking to unionize, as opposed to a secret ballot election, which is traditionally the process. What that does is make it much easier for the union to establish their foothold, because they just really need to get a certain number of employees to sign off that they want the union. They don't have to even hold an election, and then they automatically become the union for that employer. So this would be lasting for 5 years. It's a huge victory for labor and unions, of course. And there's kind of two options for how employers can, in the agricultural space, can deal with this. So number one, they have this option to agree to what's called a labor peace compact, where employees or the employer is prohibited from making any statements for or against the union, or conducting what's called captive audience meetings, where they require employees to come and attend meetings where they talk about things like the benefits that they offer, why it might not be a good idea to join the union. So the employer, if they agree to a labor peace compact, they can't do any of that. And in that case, then employees would still participate in an election, although they can vote via mail-in ballots. If the employer does not agree to a labor peace compact, then we go to that card check process, where the union can simply submit those authorization cards signed by a majority of employees, and they're automatically certified. So we are likely to see an impact in the agricultural space, where we're just going to see a lot more union activity popping up. There's also talks about amendments to this bill being proposed that would just remove that labor peace compact option and just go to a pure card check process. So not even give employers an option one way or the other on this. So we have to see if that ends up getting passed. But if you do need labor relations assistance, CEA can help out with that. We have labor relations expert, whether you're in the agricultural space or not, we have experts that can help you navigate some of those issues. If you are in the ag space, you do want to remember that it's important that you go and elect whether you are going to agree to that labor peace compact. With the Labor Relations Board, they're going to create a portal for you to be able to do that, so that you are documented whether you have agreed to a labor peace compact or not. So that should be something that you put on your to-do list to make a decision about that. All right, and the last one here has to do with CalWARN and requiring call center employers to be subject to CalWARN's requirements. So as a refresher, a lot of employers already fall under CalWARN if they employ 75 or more persons at their work site. And what it requires is that you provide advance notice before you engage in a mass layoff, relocation, or termination or plant closure. with your employees. So you have to let the affected employees know at least 60 days in advance, and you need to alert the EDD to that. Mass layoff, relocation, termination have very specific definitions under the law for when they're triggered. So a mass layoff, we're looking at when you're laying off 50 or more people within a 30-day period, for example, then you're going to trigger Cal Warren's requirements. If you don't do that, then employees can go after back pay and penalties, and it can be a big mess. So that's why it's really important, if you are at that 75 or more person threshold, that you make sure that you're considering Cal Warren. Federal Warren applies if you're a little bit larger than that. So now call centers are going to be subject to this law as well. All right, so let's go over some of our takeaways in this section. If you're unsure, make sure that you consult legal counsel to determine whether you're a covered employer for any of these new laws. For fast food, you know, we kind of just have to watch out for what's going to happen. The law is on hold now, but we never know how things are going to go. So just keep an eye out for that ballot election that's coming on that issue. For agriculture, we recommend that you work with a labor relations expert or legal counsel to determine whether you're going to agree to that labor peace compact, whether it makes strategic sense for your business. And then for call centers, we recommend preparing template warn notices and just starting to familiarize yourself with that process, so that if you do need to engage in layoffs, plant closures, those kinds of things, that you are ready to go and you make sure you have that advance notice. All right, so let's talk about what is next. I'm going to jump into that Cal OSHA standard and also go over some new cannabis guidelines that we are expecting for 2024. So on December 15th, Cal OSHA Standards Board voted to adopt what they are referring to as a permanent COVID standard. It's not actually permanent. How it works is if it's made official, it will last for 2 years, and it would replace the current emergency temporary standard that we've been operating under for the past few years. So as a reminder, the emergency temporary standard has the majority of our COVID workplace rules when it comes to needing to have a COVID prevention program, certain testing requirements, precautions that we need to take during outbreaks, and precautions in our workplace. Those all come from Cal OSHA's ETS. So this permanent COVID standard would carry over many of the ETS's same requirements, subject to some minor changes. But really, we're looking at, again, the status quo continuing on many of our COVID rules for the next couple years. Now, this isn't quite official yet. So where it's at in the process is it's awaiting approval. The regulations are awaiting approval from the Office of Administrative Law. So what OAL does is just make sure that Cal OSHA went through the proper steps to enact that regulation, that they gave prior notice, allowed for public comment, those kinds of things. That's what's being reviewed here. And that can take up to 30 working days. And while we're waiting for OAL to give us the green light that this new permanent standard is now in effect, the emergency temporary standard is remaining in effect during this time. So we're just continuing under the old standard until the new standard comes in and replaces it. Now, the biggest change with this new standard is, if approved, exclusion pay obligations are going to end. So as a reminder, exclusion pay is that requirement that when somebody has a work-related exposure to COVID and they need to be excluded from the workplace, they can't be working, that you have to continue to maintain their pay and benefits. So that has been pretty costly for employers. So this should be a welcome change for a lot of businesses if that obligation ends. As Mary mentioned, for those employers with 26 or more employees, we've already seen supplemental paid sick leave or COVID sick pay expire in December. So if exclusion pay obligations end and you're dealing with a COVID related issue, we would really be looking at most of our regular leaves of absences. So we would just be assessing, does that person need to take a paid sick leave? Do they need a reasonable accommodation for a medical condition under FEHA? We would just be reverting back to the rules we kind of already know as HR professionals. So we don't want to assume that if somebody's coming to us with a COVID related issue, that they're not entitled to protected leave time or certain rights. But we would just be looking at those other leaves that we've already been familiar with before COVID has hit. So follow our blog for updates. We are going to announce this as soon as we know. This actually, according to Cal OSHA's website, was supposed to happen in January, but we are now at February 1st. We still have not heard word on this, so I do suspect that it will be any day now that OAL approves those regulations, but we'll just have to wait and see when that officially happens. All right, and here is the last bill that I want to cover with you today, AB 2188, and what it does is create a new protected class for cannabis users under the FEHA, just like that reproductive health decision-making did that Mary talked about. But this would not go into effect until January 1, 2024. So we still are a year out from when this would actually have an impact on employers. But here's how it would work. So an employer starting in 2024 cannot discriminate or take adverse action against an employee or applicant for using cannabis while off the job and away from the workplace. So an example could be you might be interviewing an applicant and you find out that they use cannabis in their personal time. You would not be able to use that as a reason not to hire them, or you could be subject to a discrimination lawsuit under FEHA. The law does not permit, though, an employee to possess or be impaired by cannabis while on the job. So it doesn't mean that they can bring it to the work site or that they can be under the influence of it at work. So you can still have a zero tolerance policy when it comes to your workplace. You just would not have a say in what people do in their off time when it comes to cannabis use. Of course, there are exceptions as a result of good lobbying. Building and construction industries are exempt from this law. And then also if there's certain federal or other state requirements related to testing or prohibiting cannabis use, then those would still govern. So for people that fall under federal contracts or DOT regulations, this law would not change any of those rules. It is going to complicate testing when it comes to cannabis. We get a lot of questions about this. So what the law says is that employers starting in 2024 can still test for THC when they're allowed to drug test. So for pre-screening, post-accidents, reasonable suspicion, those kinds of situations. But they can't test for other components in cannabis that can show up later, weeks later after somebody has used cannabis in their hair, and those kinds of things. Now, the problem is that we are hearing that drug tests currently cannot distinguish between THC and those other components that pop up, even if somebody's used it weeks prior. So we'll have to see what happens. I suspect this is why they've set this date out for another year, to hope that the technology catches up. But I also wouldn't be surprised if they maybe amend the bill and start it in effective date as of 2025, if that technology has not caught up, where the test can distinguish between THC, which indicates that maybe somebody's used it within the last few hours, they might currently be under the influence, versus those other components indicating that no, they used it, a few weeks ago and they're not currently under the influence. So stay tuned for more details in 2023 on this. We'll see if there's any additional changes. But we have our last poll for you. We'd like to know, do you currently drug test at your organization? So I'm going to launch that last poll here. And we'd like to know if you do only pre-screening for applicants, or if you do it kind of in all situations when permitted, reasonable suspicion, post-accident, or not at all. So will this impact you? All right, it looks like the majority of you do not drug test at your organization. I'm going to end this poll and share results here. So 71% of you do not engage in any drug testing at all. Small percentage just for pre-screening, and everybody else is kind of yes when permitted. So if you do currently test for cannabis, then this could potentially impact your policies in 2024. Thank you for your participation on that. I'm going to go ahead and move us along to close out here and go over some final reminders. So As Mary mentioned, there's a number of policies that should be updated for 2023 based on the changes. So this is a really good year to take a look at your employee handbook, particularly the leave policies and those employee protections that we talked about, and ensure that you have the mandatory poster updates in your workplace. You usually can take care of that by just getting that all in one poster for 2023. We're going to make sure that we are following the minimum wages and exempt salaries properly, including those local minimum wages based on where you have people physically working or visiting client sites. And then we're going to always be monitoring our safety policies with our IIPP and COVID prevention program. So again, that should be on your to-do list. Once we have that standard from Cal OSHA, that permanent standard that becomes effective, we're going to see an update to the CPP, and we're going to want to go ahead and revise that based on what Cal OSHA provides. Again, follow our blog. This is kind of the heavy lifting at the beginning of the year with all of our new bills, but things change all the time with agency regulations, case law throughout the year. So our blog is a really great way to stay up to date on that information. Also, if you feel that you need support beyond the hotline, you can join as a CEA member and get access to all of those forms and toolkits that I mentioned, as well as get some consulting hours if that's the level of membership that you need, where we're working with you on things like handbooks, HR audits. We're happy to help you. So just give us a call if you'd like to learn more about that. I also want to remind you that you can contact the Monterey County Workforce Development Board. So as Jerry mentioned, reach out to them, and thank you to the Monterey County Workforce Development Board for sponsoring today. We really appreciate your partnership with us. And I'm going to turn it over to Tara for just a couple last housekeeping items.
Awesome. Thank you, Juliana. So yes, a couple of housekeeping things. So we've got the, if you're doing any kind of education, continuing education, here are the codes. The HRCI code is 616082. And the SHRM code, if you're looking for that, is 23 dash, and you can't forget that dash, A as in apple, 3, P as in Paul, T as in Tom, J as in Jerry. And I'll also put those in the chat box so you can just lift that from there if you're looking for those. Let's see, the next slide, I believe, is our QR code for the survey. So if you will just take a quick picture of that, that would be great. It'll take you straight over to the survey. It'll take you less than 30 seconds to fill out. It's really quick and simple, and we would absolutely love your feedback. So thank you for that. And then a couple other reminders. So I will put in the chat the upcoming events that Jerry was talking about earlier. We've got one on March 8th, which is Leading Change and Surviving Change. And then we also have the one that is going to be in person. So I'll put that in the chat. So you've got those dates as well. So there's that for you. Along with this webinar is being recorded. It will be on the Monterey County Workforce Development Board's website. So here's that for you. The hotline for you guys, I am putting that in the chat as well. That number is 888-217-6899. And last but not least, Jerry, I'm going to put your information in the chat as well, and I will pass it over to you, and you can close us out.
Thank you so much. As you can see, there's a lot of information to cover. We don't have enough time, but I do want to remind you that there are a number of webinars that we want to have you return to. And we have 2 on-site visits. Hiring right the first time is going to happen in April. So those who have the opportunity to participate in an in-person presentation by the CEA, California Employers Association, will be able to meet them in person, as well as then you'll be able to hear that. So again, feel free to contact me, Jerry Hernandez, 831-755-5393. Thank you again. We look forward to having you back with us next time.
Thanks, everybody. Thanks, ladies. It was great information. And thank you, everybody, for your participation. Have a great day. Stay warm and stay healthy. Bye-bye.